Hello everyone, I'm Ankit and you're watching StudyIQ IS English. In our today's video, we'll talk about what was the Supreme Court's legal opinion on the 14 questions that were asked to it by the President of India using her power from the Article 143 of the Indian Constitution. Now, in our today's discussion, the note that I will be using, in case if you want to download them, you can go to this particular Telegram channel called as ATS Live. And while you're at it, please do not forget to subscribe to the channel also. So let me first give you a background of this issue, then I'll talk about the context of our today's discussion, and then we'll discuss what are the legal opinion of the Supreme Court all about from this presidential reference. Okay, so let us start by the background of this issue, because before understanding the background, everything else would become secondary, right? Now you need to understand governor is the head of a state government who is appointed by whom? Who is appointed by the central government. So many opposition ruled parties who are ruling over the state governments in different parts of the country, they've accused governors in their respective state of deliberately delaying the assent of the bill. Now you need to understand a bill is a bill which is passed by the state legislature. But before this bill becomes an act, there is a very important constitutional requirement that is supposed to have, that is giving of assent by the governor of a particular state. So when governor delays giving his or her assent to a bill, it won't become an act. So this was the source of grievance as far as the state government is concerned. So this matter ultimately reached the apex court of our country, which in April 2025, the two judges bench of Supreme Court gave a judgment. Now this judgment naturally created a lot of controversies. Why it created controversy? Let us understand this. Now Supreme Court in this judgment imposed a time limit on president and governor in order to give assent to a bill passed by the state legislature. It stated that if this bill is given to the governor for his or her assent, the governor has 3 months to give their assent. And if this bill is referred back again to the governor after being reconsidered by the state legislature, then in that case, the governor would have 1 month deadline to give the assent. But this was not problematic. What became more problematic, that this time limit was also imposed by President of India, that in case this bill is reserved by the governor for reconsideration of the president, then president is also bound by this 3 months timeline within which she has to give assent to a bill passed by state legislature. So this was the problematic judgment number 1. The second part of the problem, or the second part which created controversy, was more than the first part. Supreme Court in this judgment utilized extraordinary power which is provided to it by Article 142 of the Indian Constitution to bring upon a concept which is not there in the Indian Constitution, the concept of deemed assent. So the Supreme Court stated, if president of the or the governor, if they fail to adhere to this timeline which is set by the Supreme Court, this bill automatically would be considered to have been given the assent. And who gives the assent in this regard? It is automatic assent or deemed assent given by the Supreme Court using its power under Article 142. So that is why, because of these two reasons that I enumerated, this judgment of the Supreme Court, which came by a two-judge bench, became controversial. Now to deal with this controversy, President relied on the power that is given to her under Article 143. And in this, using this power under Article 143, President sought the Supreme Court's advisory opinion. Now this use of Article 143 by the President is a rare event. Before this, it has only happened 15 times from the time Constitution has been enacted. And this was done usually when any major constitutional dilemmas happen. So this use of extraordinary power by the president under Article 143, it stated that this issue has escalated beyond the purview of one particular state and it needed an authoritative settlement on the governor's power, which has to be given by none other than Supreme Court. So this is why this issue has become so prominent. So in the context of our today's discussion, we will discuss what is the judicial opinion or what is the advisory opinion given by the Supreme Court on the questions that was asked to them by the President of India using her powers under Article 143, right? And this opinion also becomes significant because it was given days before the retirement of the present Chief Justice of India, Justice Gavai. So in this regard, we'll try to understand what are the questions that was asked by the President and what are the respective answers that have come back from the Supreme Court to the President in this presidential reference question. Now let us start with the first question. The first question that was asked by the President of India to the Supreme Court is that what constitutional options does governor have when a bills come to it from after being passed by the State Legislative Assembly. Now you need to understand this all is addressed by Article 200 of the Indian Constitution. Article 200 of the Indian Constitution outlines certain provisions that the governor needs to follow when a certain bill is passed by the state legislature and it comes to the governor. So in this regard, governor has three options. Governor has the option to sign the bill, which is officially called as granting of assent to the bill. Second option that the governor has is to withhold the assent. Withholding the assent means denying the signing of the bill by the governor. And the third option that the governor has is that the governor can reserve the bill so that it can be reconsidered by the president at a later date. So these are the three options that the governor has under the Article 200. Now Supreme Court in this question said that when governor withholds the assent to the bill, that does not mean that the governor has to sit on this decision. The governor under Article 200 of the Indian Constitution is bound to forward this bill for reconsideration of the State Assembly. So this simply means that the governor can't keep the bill pending just by withholding the assent. By withholding the assent, the governor has to make sure to forward this bill to the state legislature so it can be reconsidered by the state legislature, right? So this was the first question where the Supreme Court narrowed down the discretion that the governor enjoys using their power under Article 200 of the Constitution. Now the second question comes is when deciding on the bill whether to give assent to the bill or not to give assent on this bill. In this regard, is governor bound by the aid and advice which is given by the Council of Ministers of the state government? Now Article 163 of the Indian Constitution deals with this particular provision. So if you read Article 163, you'll realize that governor must act on the aid and advice of the Council of Ministers. But the second para of this Article 163 says that governor is not expected to follow the aid and advice of Council of Ministers if the Constitution requires them to exercise certain discretion. So the Supreme Court stated when governor is bound by a bill which has been passed to it by the state legislature, so in this regard, whether to give assent or not to give assent, this matter is of governor's personal discretion. He in this regard or he or she in this regard are not bound by the aid and advice of Council of Ministers, because if they were bound by the aid and advice of the Council of Ministers, so in no case governor could have refused an assent to a bill which is promoted and passed in the state legislature by the sponsorship of the state government. So when it comes to deciding on the bill, that is whether to give assent or not, here governor is not bound by the advice of Council of Ministers. Rather, it is governor's discretion whether to give assent or not to give assent, right? So this was the question number 2. Now let us talk about the question number 3. Now you need to understand when governor gives their decision on a particular bill, that is to give assent or not to give assent, is this decision by the governor subjected to judicial review? This was the third question put forward to the Supreme Court by the President of India. Now the Supreme Court stated that when governor gives a decision which is based on merit, and this substantive decision of the governor will not be judiciable or will not be justiciable. This means that this power of the governor is not subjected to judicial review by the court of law in India. However, Supreme Court added a caveat. Supreme Court stated that if governor does not take a decision by prolonging it, does not explain the decision, or is indefinitely delaying the decision-making part on a particular bill, then that inaction by the governor is subjected to judicial review. So the Supreme Court stated, once again I'll clarify it, Supreme Court stated if governor makes a decision to withhold the assent or to give this assent, this means it won't be subjected to judicial review. But if governor delays on giving the decision, which means governor is delaying on giving the assent, then it would be subjected to judicial review of the Constitution. Because if governor sits on a bill without taking any decision, then it is the power of the court to direct the governor to take the decision as soon as possible. So this was the question number 3. Now let us talk about another question. Many people have claimed that when there is Article 361 of the Indian Constitution, which grants president and governors in a state to exercise immunity, that is being not answerable to a court of law when they are performing any duties of their office. So it basically makes governor and president immune to judicial review. So many people have stated that when Article 361 is in Indian Constitution, so why are courts reviewing decisions given by the governor and president? This is a legal question, right? So the Supreme Court stated that Article 361 does not absolutely bar the judiciary from reconsidering or reviewing any act of the president or the governor. The court stated that while this Article 361 protects the individual who is in the office of the governor, but it does not protect the office of the governor from judicial scrutiny. And this immunity can't be utilized as an excuse or as a blanket to protect themselves from delaying or indefinitely delaying the decision-making process when it comes to giving or not giving an assent to the bill. Right? So Supreme Court once again stated that Article 361 of the Constitution does not absolutely bars the court from undertaking judicial review. Right? So this was another question. Now, the biggest aspect of this particular reference. The president asked that can Supreme Court or can courts in India impose a timeline when it comes to governors on following this timeline to give an assent. The Supreme Court again stated that they can't impose a timeline on the governor to delay or withhold the assent on a particular bill. So Supreme Court in this regard overruled its April 2025 judgment, where you can remember they imposed a specific timeline both on president and governor, how they have to act and in which time they have to act on a bill. Now it stated that since Article 200, if you read it, uses the phrase called as soon as possible, so it means that Constitution is not adhering to a fixed timeline, rather it is a flexible timeline. So when it comes to Supreme Court, it would be inappropriate for them to prescribe a rigid deadline, which it did so in the April judgment. So that is why it overruled its judgment in this reference of the president. Now another part is that when president utilizes their power given to it under Article 201 to give or to not give an assent to a bill passed by state legislature, then is this subjected to judicial review? So following the same decision which came after Article 200, the Supreme Court stated that this is not subjected to judicial review because Article 201, it deals with bills which are reserved by the governor for president's reconsideration. So similar to governor, the president's decision to assent or to withhold the assent to a particular state bill is not open to judicial review on its merits, right? So this was another question. Now the next question also dealt with, can Supreme Court impose a timeline on president just like it did for the governor? Again, the Supreme Court stated that they can't impose a timeline on president because the president also is bound by the provision of Article 201, which states as soon as possible. So when Constitution itself is not prescribing a rigid timeline, so is the Supreme Court to prescribe a rigid timeline, right? So this is the same kind of a judgment or the same kind of an opinion which was given by the Supreme Court for the governors as well. Now then came the question whether the courts can adjudicate on different aspects of the bill. The Supreme Court also stated in this question, no, they can't. Why it stated that? Because you need to understand law and bills are different. Bills, for that matter, are proposed legislation. So for a bill to become an act or for a bill to become a law, that needs assent by the president or the governor. So it is the law which is an enacted legislation, whereas bill is just a proposed legislation. So what can courts do is that it can review the contents of a law which has been passed and given the assent by the president or the governor. When it comes to bill, the court cannot adjudicate on the validity of a bill unless it doesn't become a law or an act. Right? So this was another question that was addressed by the Supreme Court. Now, in this regard, can the court become or give the assent to a law which usually is given by the governor or the president? Now in this regard, the Supreme Court clarified that no, a law of a state legislature can't become an act without the possibility of governor's assent. So for a bill to become a law, it needs assent. Either it should be given by president or it can be given by governor if it is not reserved for the president. So it is not the courts that can give the assent, rather it is only the governor or president who can give the assent. Similarly, one of the key issues that was addressed by the Supreme Court in this presidential reference, it pertains to use of its power under Article 145(3). Now, whenever a substantial question which pertains to a constitutional issue is referred to the Supreme Court, usually those matters are heard by a constitution bench. Constitution bench is a bench of judges which consist at least 5 number of judges, and this is provided under Article 145(3) of the Indian Constitution. So a question was imposed by the president that is it mandatory for a Supreme Court bench to first analyze whether the matter which has been put in front of us, it deals with a question which carries the constitutional weightage, or should it be considered by a constitutional bench? Now this question the court declined to answer. The court said that this query first of all was irrelevant to the fundamental nature of this particular presidential reference, because this particular reference dealt with issues of legislative assent when it has to be given by governor or the president. So Supreme Court in this regard refused to answer a question whether similar kind of a query, if it is facing, whether they should let the bench decide to allow this matter to be heard by a constitutional bench. Now the next question was the nature of power which is provided to the Supreme Court under Article 142. If you can remember the background that I told you, Supreme Court used its extraordinary power under Article 142 to provide a concept of deemed assent. So the question that was asked to Supreme Court by the President of India, that is this power which is given to Supreme Court under Article 142, is it just limited to procedural aspects of the law, or does it extend, or does it give infinite power to the Supreme Court of India to issue directions or to pass an order which might be contrary or even inconsistent to the rule of land, that is either constitution or a law passed by the legislature. So theoretically, can the Supreme Court of India overrule the provisions of the constitution or a law enacted by the parliament to prescribe something parallel to the law? The answer in this question was not definitive, but Supreme Court clarified one thing. Supreme Court stated that although this question is a good question, but it is too broad to answer right now, but it gave a particular directed impactful result. It stated that Article 142, which it used to provide deemed assent, cannot be used to override a substantive constitutional provision which is mentioned under Article 200 and the Article 201 of the Indian Constitution. Because if you remember Article 200 and 201, it states that a bill becomes an act only when it receives assent either by governor or the president. So it is not the Supreme Court using their power under Article 142 can provide the assent. It can only be provided by governor and the president or the president, right? So therefore, this article can't be used to provide for something which is otherwise mentioned in the constitution, right? Now the last question was pertaining to disputes between union government and state government. Now you need to understand the Supreme Court of India has original jurisdiction when it comes to solving the disputes between union and state government, and it falls under Supreme Court under Article 131 of the Constitution. Now the court stated that the presidential reference asked this question to the Supreme Court: can you solve any dispute between central and state government beyond the scope which is provided to it under Article 131 of the Constitution? Now this question also was not answered by the Supreme Court. So the bench, it deemed this matter irrelevant because the specific issue dealt with governor's power when it comes to giving assent. So that is why this answer was not given by the Supreme Court. Now, before solving the practice question which pertains to the exact discussion that we had today, I have something important that I need to tell you. Now, this particular judgment that we're dealing with, it dealt with many articles of the Indian Constitution. It dealt with Article 200, Article 201, it dealt with Article 143, it dealt with Article 142. Now, all of these are important articles as far as Indian polity is concerned. But what about other topics? What about fundamental rights? Forget about polity. What about other subjects? Economy, IR, history, geography, you name it. Now, to understand each and every subject in detail, you have one good option. if you take our courses, that is Resolution, P2I Foundation batches, each and every important subject of UPSC from GS point of view and also from CSAT point of view, everything is covered in our batches. Now we have separate batches for students who are looking to give exams either in 2021, 2027 or in 2028. So you can take admissions to either one of them. But if you use the code ATS Live, it will help you fetch maximum discounts. That is, you can get discounts up to 7,000 rupees. But you will get only that after you apply the code ATS Live. So learn to thrive with ATS Live. Now, this is a practice question which is very similar to a question that appeared in 2019. A question has appeared in exam relating to Article 142. So I have changed that question to suit our today's discussion. Do let me know the correct answer to this question in the comment section. And what do you think about this judgment or the opinion given by the Supreme Court of India? Is it a balancing act of Supreme Court, or has Supreme Court made a definitive change as far as the relations between governor and the state government is concerned? Do let me know your opinion in the comment sections. We are not judiciary. We are open to all comments, whether it is criticizable or not. Please do let me know in the comment section. And if you want to download the notes, they will be available on this particular Telegram channel, ATS Live. Okay. So I'll see you each other again tomorrow. Please have a very good night and a very good weekend.